And thanks to At Home for joining us this hour. So the Axis powers in World War II were Germany, Italy, Japan, right? There was the Allies on one side, the Axis on the other. That was the Axis. At the time of World War II, and in the years leading up to it, of course, there were many millions of American citizens in this country who were of German origin, lots of German-American citizens here. Also tons of Italian-origin American citizens, Italian-Americans all over this country. But it's interesting. German-Americans and Italian-Americans didn't all get put in internment camps during World War II, right? They weren't rounded up, the Germans and the Italians in this country. Of the Axis powers, it was only Japanese-Americans who got put in internment camps en masse in World War II. Why was that? Why was it just them? In 1982, a legal historian, lawyer named Peter Irons, was going through boxes of government documents. He was researching the origins of that World War II policy in which the US government locked up Japanese Americans. And much to his surprise, Peter Irons stumbled upon a whole bunch of evidence about where that policy had basically come from. And it was evidence that had been lost to history. It had never been made part of the official record, never been made part of the government record, the historical record, or the legal record of where that policy came from. FDR issued an executive order to lock up Japanese Americans in February 1942. That executive order cited military necessity as the reason why all Japanese Americans had to be locked up. It cited the military necessity of protecting the homeland, essentially, from Japanese Americans who would want to sabotage and subvert the war effort here at home. Quote, "The successful prosecution of the war requires every possible protection against espionage and against sabotage to national defense material, national defense premises, and national defense utilities." The basis for that military necessity claim, the key basis for that, was a report that had been prepared by a U.S. Army general. It was a report on the possibility of Japan attacking the west coast of the United States. And that report asserted that Japanese Americans living in the United States would assist Japan in any such attack. That Japanese Americans would commit acts of espionage and acts of sabotage against the U.S. government and the U.S. military. In that same report, that general asserted that the, quote, racial characteristics of Japanese Americans predisposed them to assist Japanese forces in any such attack. He also said it was impossible to distinguish loyal from disloyal members of that racial group. On the basis of those findings, this report from this U.S. general advocated that all Japanese Americans should be rounded up forcibly and put in remote concentration camps for the duration of the war effort. It was a military necessity. And, you know, that's interesting that one general thought that. But it turns out he didn't represent U.S. government consensus conclusions on that point. It turns out, in fact, that the War Department at the time kind of thought that he was cuckoo for Cocoa Puffs. The War Department issued strong objections to that general's report. They made a whole bunch of changes to his report because the War Department thought that he was wrong about a lot of his conclusions and his premises. When the War Department ordered his report changed, the general then ordered that all the original copies of his report should be withdrawn from circulation and burned. And he then denied that any initial report had ever existed. He denied the fact that there had been these revisions. The government pretended that this original draft didn't exist, that there'd never been these revisions, that there'd never been these objections from the War Department. They made no formal record of all these objections from inside the military, the ones that led to his first report being burned and a second one being issued in its place. Navy intelligence, it turns out, filed a competing report saying the supposed threat of treason by Japanese Americans was being vastly overstated. Quote, "In short, the entire Japanese problem has been magnified out of its true proportion, largely because of the physical characteristics of these people. This should be handled on the basis of the individual and not on a racial basis." By 1944, after the policy was already in effect, the War Department had documents in which they were bluntly asserting that the supposed military justification for rounding up Japanese Americans was bunk. This was still during the war. quote, the vast mass of fifth column folklore, insofar as concrete evidence is concerned, is almost entirely baseless. That was the War Department during 1944. So here's the problem. Here's the legal problem. Japanese Americans who were rounded up and put in these internment camps because of FDR's executive order, they challenged the internment camps in court, including Fred Korematsu, a Japanese American who was picked up off the street in San Leandro, California during the war. He was fiercely opposed to internment. He thought it was wrong. He fought it. His case went all the way to the United States Supreme Court, and Fred Korematsu at the United States Supreme Court lost. The justices in 1944 cited the, quote, real military dangers presented by the government to justify the internment policy. What Peter Irons later discovered in those dusty boxes of government documents years later is that there was no such clear determination of military dangers that justified locking up all Japanese Americans. The Justice Department, in fact, at the time, had all sorts of contrary evidence. They had all these internal reports, they had intelligence documents, they had findings from within the War Department that totally disputed this contention they were maintaining publicly that there was a consensus within the military of a need to lock these Japanese Americans up. When it came time to defend the internment camps in court, the government lied to the court when they withheld all of that contrary evidence from the government's own files about the wobbliness of this contention that there was some military necessity that was undergirding that policy. The military didn't think there was any such necessity. There was no consensus about that, but the government lied and said that there was a consensus, that everybody agreed that that was clear. So that policy was signed into law in 1942 by FDR. Over 100,000 Japanese Americans were locked up. It wasn't until 40 years after the policy was implemented that Peter Irons found all that lost evidence in dusty, misfiled, mislabeled boxes in the bowels of the Justice Department. And when he came across those documents in 1982, he came across this stuff showing that the supposed military necessity for the internment camps was not at all the way the government had described it in court. He knew when he saw those documents that what he had found was probably going to change the history of Japanese internment in this country. Reporter Avi Selk wrote about this for the Washington Post last year. Quote, the lawyer had stumbled across the papers in a government storeroom, secret admissions from U.S. officials that a supposed matter of national security was not what it appeared. The executive order led to abrupt expulsions, mass detentions, and the persecution of thousands on the basis of their ethnicity. But it was false to the core. Peter Irons, the lawyer, intended to prove it, but he couldn't do it by himself. With the documents in hand and a knot in his stomach, he stepped out of a taxi in San Leandro, California in 1982, and he walked up to the home of Fred Korematsu. Peter Irons knew the man only by reputation. Long ago, Korematsu had been arrested in this city, his hometown, for defying an executive order that led to the expulsion or imprisonment of more than 100,000 Japanese Americans. Korematsu had gone to court to fight it, but in 1944, he lost in the Supreme Court. Defeat changed Korematsu. For decades, he'd been living quietly in a small house, refusing to discuss his case with anyone, even his own children, blaming himself for what his government had done to his people. It had taken Peter Irons 2 letters and a phone call just to get an audience in Fred Korematsu's living room. Now he sat across from the man, nervous, hoping that seeing incriminating documents the government had kept secret during his trial would convince him to fight again. Korematsu was a quiet man. He sat in his chair, puffed on his pipe, and he read Peter Irons' papers in total silence. Irons later recalled, quote, at least 20 minutes passed without a single word being said. Then he looked over at me. And he said, would you be my lawyer? When Fred Korematsu had gone all the way to the Supreme Court back in the 1940s and lost that case, the Supreme Court upheld internment camps for U.S. citizens on the basis of race. And they based that court ruling on the government's contention that there were clear findings of a military necessity that justified that policy. There were no such clear findings. That court ruling was based on a false premise. And the documents proving that were discovered 40 years later, and Fred Korematsu did decide to go back to court. And this time he won. He got his conviction overturned. The judge in his case told the courtroom that the government's position was, quote, tantamount to a confession of error. It still took a long time, but in 2011, the U.S. Justice Department officially made a formal concession of error in the internment camps case. The U.S. government formally acknowledging that the government's defense of the internment camps, the government's defense of that policy creating the camps, that government defense was built on a lie. They had withheld evidence from the court. Tonight, we have been watching protests unfold around the country in response to the Supreme Court ruling to uphold the Trump administration's Muslim ban. The first iteration of President Trump's Muslim ban, you might remember, didn't survive the first weekend of the new administration. The second iteration of the Muslim ban was partially blocked before it even went into effect, and then the rest of it expired. Since then, they've been pushing for a third iteration of the Muslim ban, and today that is what was upheld at the U.S. Supreme Court. In a 5-4 decision, the conservative majority at the court decided to discount the anti-Muslim statements from President Trump that he has used consistently to explain the policy and justify the policy. The majority instead decided to believe that there were national security concerns of some kind. That must be what really undergirds the policy, regardless of what the president has said. It was a 5-4 decision. All the hardcore conservative justices appointed by Republican presidents sided with the Trump administration, including Anthony Kennedy, including Neil Gorsuch, who was only nominated to the court after Republicans in the U.S. Senate held a Supreme Court seat open for more than a year, rather than allowing a hearing on a vote for a hearing or a vote on a nominee from President Obama. That's how Neil Gorsuch got that seat, which is totally unprecedented in the history of the court. The Gorsuch example, though, is now the new precedent for how the U.S. Senate will handle vacancies on the court. The Gorsuch experience means, realistically speaking, that if and when Democrats take back control of the U.S. Senate, they too will not allow any seat on the court to be filled until a president of their party is in office to make a new Supreme Court nomination. That's the new precedent now, because of Senate Republicans and what they did to give Neil Gorsuch his seat. The Gorsuch seat, what Republicans did to give him that seat, to deprive President Obama the opportunity of nominating his own candidate, that is the new reality of how the court will be treated from here on out. And with all of these really quite aged justices and Democrats hell-bent on taking back both houses of Congress as soon as they can, because of that Gorsuch precedent, we are on the cusp of a really strange new era in constitutional governance in this country. You should know in the short term tomorrow, there's likely to be another blockbuster conservative ruling that is likely to gut union rights in this country. Today, alongside the Muslim ban ruling, we also got another fairly radical 5-4 conservative ruling against abortion rights. Republican Senate leader Mitch McConnell has bragged that blocking President Obama from making a Supreme Court nomination was the most consequential act of all his decades in public office. I am quite sure that Mitch McConnell is very much right about that. But the response to the Muslim ban ruling today hasn't been the typical response to just another typically conservative ruling from this conservative court. And I think the significant reaction that you've seen today to this Muslim ban ruling is in part because one of the two dissents in the case from justices who disagreed with the majority ruling, one of the two dissents today went off basically like a bag of firecrackers in a small enclosed space. When justices disagree with the majority ruling, they don't have to spell out their reasons for their disagreement. When they do so, it's published alongside the majority opinion as a published dissent. They always end with the justice saying, "I respectfully dissent," unless the justice in that particular case is really mad, in which case the justice might drop the respectfully and say, "I dissent." If a justice is really, really, really mad, he or she might elect not just to drop the respectfully. Sort of the next step they might take is to go beyond even just publishing a written version of the dissent. Justices, when they're really fired up, sometimes decide to read their dissent from the bench. Today, Justice Sonia Sotomayor did both of those things. She did not, quote, respectfully dissent. She just said, "I dissent." And she read her dissent out loud in court. And at the apex of her argument, she cited the Korematsu case, the infamous Fred Korematsu Supreme Court case, the flawed Supreme Court case from 1944 that upheld the internment camps on the basis of supposed national security concerns that the government lied to the court about. The revelation of those lies before today had already led to the overturning of Fred Korematsu's individual conviction. It had led to a formal apology from the Justice Department for having lied to the court. But before today, the Korematsu ruling was still technically on the books. Sotomayor cited the Korematsu ruling today in her dissent. That led Chief Justice John Roberts to basically renounce her for citing that case. He said it was totally irrelevant to the Muslim ban ruling today. But then he issued essentially a one-line statement declaring that once and for all, Korematsu is hereby officially overturned as of today, which is great. I mean, Korematsu was widely viewed as a dead letter because it has been so roundly repudiated both by history and by the legal record. But now it's officially gone as a Supreme Court precedent, which, as I say, is great. You know, just in case concentration camps based on race are something the Trump administration might want to pursue with people other than Central American migrants on the border, that one line today from Chief Justice John Roberts might make that a little bit harder in terms of Supreme Court precedent. So, yay. But check this out from Sonia Sotomayor today. In case you have not already seen what she said today, and she said it out loud, she read it from the bench, you should know that this is what she said. Quote, "The United States of America is a nation built upon the promise of religious liberty. Our founders honored that core promise by embedding the principle of religious neutrality in the First Amendment. The court's decision today fails to safeguard that fundamental principle. It leaves undisturbed a policy first advertised openly and unequivocally as a total and complete shutdown of Muslims entering the United States, because the policy now masquerades behind a facade of national security concerns. Although the majority briefly recounts a few of the statements and background events that form the basis of plaintiffs' constitutional challenge, that highly abridged account doesn't even tell half of the story. The full record paints a far more harrowing picture, from which a reasonable observer would readily conclude that the proclamation was motivated by hostility and animus toward the Muslim faith. During his presidential campaign, then-candidate Donald Trump pledged that if elected, he would ban Muslims from entering the United States. Specifically, on December 7th, 2015, he issued a formal statement calling for a total and complete shutdown of Muslims entering the United States. On December 8th, 2015, Trump justified his proposal during a television interview by noting that President Franklin D. Roosevelt, quote, did the same thing with respect to the internment of Japanese Americans during World War II. In January 2016, during a Republican primary debate, Trump was asked whether he wanted to rethink his position on banning Muslims from entering the country. He answered no. A month later, at a rally in South Carolina, Trump told an apocryphal story about U.S. General John J. Pershing killing a large group of Muslim insurgents in the Philippines with bullets dipped in pig's blood in the early 1900s. In March 2016, he expressed his belief that, quote, Islam hates us. We can't allow people coming into this country who have this hatred of the United States and of people that are not Muslim. That same month, Trump asserted that we're having problems with the Muslims, and we're having problems with Muslims coming into the country. Justice continues. Despite several opportunities to do so, President Trump has never disavowed any of his prior statements about Islam. Instead, he has continued to make remarks that a reasonable observer would view as an unrelenting attack on the Muslim religion and its followers. Taking all the relevant evidence together, a reasonable observer would conclude that the proclamation was driven primarily by anti-Muslim animus rather than by the government's asserted national security justifications. Ultimately, what began as a policy explicitly calling for a total and complete shutdown of Muslims entering the United States has since morphed into a proclamation putatively based on national security concerns. But this new window dressing cannot conceal an unassailable fact that the proclamation is contaminated by impermissible discriminatory animus against Islam and its followers. Rather than defend the president's problematic statements, the government has urged this court to set them aside and defer to the president on issues related to immigration and national security. The majority, meaning the conservative majority, accepts that invitation. Sotomayor then goes into detail describing, quote, serious questions about the legitimacy of the president's proclaimed national security rationale. She says, quote, tellingly, the government remains wholly unable to articulate any credible national security interest that would go unaddressed by current laws, absent this travel ban proclamation. None of the features of the proclamation highlighted by the majority supports the government's claim that the proclamation is genuinely and primarily rooted in a legitimate national security interest. The First Amendment stands as a bulwark against official religious prejudice and embodies our nation's deep commitment to religious plurality and tolerance. That constitutional promise is why, for centuries now, people have come to this country from every corner of the world to share in the blessing of religious freedom. Instead of vindicating those principles, today's decision tosses them aside. In holding that the First Amendment gives way to an executive policy that a reasonable observer would view as motivated by animus against Muslims, the majority opinion upends this court's precedent, repeats tragic mistakes of the past, and denies countless individuals the fundamental right of religious liberty. Today's holding is all the more troubling given the stark parallels between the reasoning of this case and that of Korematsu versus United States, 1944. In Korematsu, the court gave a pass to an odious, gravely injurious racial classification authorized by an executive order. As here, the government invoked an ill-defined national security threat to justify an exclusionary policy of sweeping proportion. As here, the exclusion order was rooted in dangerous stereotypes about a particular group's supposed inability to assimilate and desire to harm the United States. As here, the government was unwilling to reveal its own intelligence agency's views of the alleged security concerns to the very citizens it purported to protect. And as here, there was strong evidence that impermissible hostility and animus motivated the government's policy. In the intervening years since Korematsu, our nation has done much to leave its sordid legacy behind. Today, the court takes the important step of finally overruling Korematsu, denouncing it as gravely wrong the day it was decided. This formal repudiation of a shameful precedent is laudable and long overdue, but it does not make the majority's decision here acceptable or right. By blindly accepting the government's misguided invitation to sanction a discriminatory policy motivated by animosity toward a disfavored group, all in the name of a superficial claim of national security, the court redeploys the same dangerous logic underlying Korematsu and merely replaces one gravely wrong decision with another. Our Constitution demands and our country deserves a judiciary willing to hold the coordinate branches to account when they defy our most sacred legal commitments. Because the court's decision today has failed in that respect, with profound regret, I dissent. Not I respectfully dissent, but I dissent. So the Supreme Court ruling that justified internment camps for Japanese American from the 1940s, that Supreme Court ruling is dead officially as of today. For a long time, it's already been dead in a practical sense because it was shown to be based on a lie, a literal lie. The government said those internment camps were necessary for a clear national security purpose. They didn't have any clear national security purpose that justified that policy. It was actually based impermissibly on racial animus, and the government hid evidence of that from the court when the court upheld those camps. The government covered it up. They lied to the court. They got away with it for decades. But it was finally exposed. That ruling for the internment camps, the reasoning that justified them, it was finally, decades later, exposed as a sham. The justices who dissented from the Korematsu ruling back in 1944, over time have been proven correct. Today, the Korematsu ruling finally went away as formal Supreme Court precedent. In her dissent today in the Muslim ban ruling, Justice Sonia Sotomayor says the same national security claims that purport to underlie the Trump Muslim ban are also likely spurious, the way they were in Korematsu. And in this case, there's nothing secret about the animus that underlies this Trump administration policy. In the Korematsu case, the government had to lie to the court about it. It took decades to dig up evidence, right? In the Muslim ban case, there's nothing secret here. There's nothing secret about the animus at work here. The president talks about it openly all the time. Nobody has withheld that evidence from the conservative majority of the Supreme Court. They just today chose to ignore it. And this is the Supreme Court, so there's no appealing this decision. There's no appeal, at least within the court system. There's no secret history of prejudice here for a new Peter Irons to find evidence of in an old misfiled dusty box that he can then take to Fred Korematsu and beg him to bring it back to the courts. Courts won't fix this. In this case, the evidence of animus is, it's in the newspapers, it's in public statements, it's in speeches, it's in the president's Twitter feed. And now we as a country have nowhere to take that evidence except to the voting booth, because this is now something that the courts will not fix. Congress could fix it, but that would require changing the Congress.
Hey there, I'm Chris Hayes from MSNBC. Thanks for watching MSNBC on YouTube. If you want to keep up to date with the videos we're putting out, you can click subscribe just below me or click over on this list to see lots of other great videos.